I'm Arizona Divorce and Family Law Attorney Kyle Scoresby. This is a short video about restraining orders in Arizona. Restraining orders are issued to prevent an act of domestic violence. And there are really two major types of restraining orders that we're usually talking about with clients. One is called an injunction against harassment. The other is called an order of protection. The real difference between these is that an order of protection requires there to be a certain relationship between the plaintiff, the person seeking the order, and the defendant, the person you're trying to restrain from being around you. So there has to be a relationship. It's addressed in a statute. Usually it's either a spouse or a parent-child relationship or a romantic relationship that you've been in. If it's just a neighbor or something like that, that would be an injunction against harassment. So we're going to focus really the rest of this video on orders of protection, not injunctions against harassment. So for an order of protection, the statute outlines several offenses. It makes reference to several criminal statutes that might form a basis for an order of protection. These include things like harassment, assault, stalking, intimidation, disorderly conduct, disturbing the peace, some things like that. So these criminal statutes that are out there, if a person has allegedly violated some of that conduct, some of those statutes in relationship to you as a possible plaintiff, you can pursue a restraining order against that person, an order of protection. And orders of protection, they kind of have a two-part system of being issued. So initially, when you go seek an order of protection, the other side isn't there. It's just you and the judge, and you're telling the judge what happens, and you're seeking that order. And the judges usually issue those orders pretty liberally. But once that order is served on the defendant, at any time that order is in effect, which is for 1 year, that defendant can seek a hearing on that order, and a hearing has to be granted within 10 days or 5 days if the order includes exclusive use of the home. At that hearing, it's much more difficult to make that order of protection stick. The plaintiff has a burden of proof to prove by a preponderance of the evidence that the defendant committed some act that is within those statutory grounds for an order of protection. So if the plaintiff is successful and proves those grounds occurred, that the defendant committed one of those actions, the judge will uphold the order of protection. If the plaintiff fails to meet that burden of proof, the judge will dismiss the order of protection. Do not ever use an order of protection as a custody order. If you are in a family court case, there are children involved, if you need an order for custody, there's another means to do that, another procedure called temporary orders procedure in the family law case. So an order of protection is not a substitute for a child custody order. If you have been the victim of domestic violence, or there's a threat of domestic violence, and you think you may need an order of protection, or if you've had an order of protection served on you, give us a call and we can discuss that with you.